Let's bring in now Kim Whaley. She was a federal prosecutor and is now a law professor at the University of Baltimore. And Alan Tuerkheimer is a jury consultant and a senior litigation communications expert. Great to have both of you. Let me start with you, Kim. I just want to play for our viewers what happened yesterday in terms of, I think, the crux of the matter of the closing arguments. One from the defense attorney, one from the prosecution, of what I think this hinges on. So listen to this moment.
There is no doubt in this case that the defendant committed these crimes. The question is whether or not you believe that his actions were legally justified. And I submit to you that no reasonable person would have done what the defendant did.
Every person who was shot was attacking Kyle. One with a skateboard, one with his hands, one with his feet, one with a gun.
Kim, do you have an impression of which will be more convincing for the jury?
Well, I think it depends in part on which death the jury is focusing on, and I'm not surprised in the lead up that the jury instructions are confusing. 36 pages of jury instructions. So the first person who died, Mr. Rosenbaum, was apparently mentally ill, had just been released from a hospital, was acting erratically, and did, you saw it in videotape, run towards Mr. Rittenhouse, threw a plastic bag at him, and at the same time somebody else shot a firearm. So the question there is, did Mr. Rittenhouse feel that he was in harm's way? That's I think a little easier for Mr. Rittenhouse and harder for the prosecution. After that, he started running. He left this dead body and then started running with a gun. And then Mr. Huber, unarmed with the skateboard, went to try to stop what many people, it sounded like, thought was an active shooter. For there, self-defense, I think, is much harder. And the provocation instruction, which in my view is actually quite confusing in the actual jury instructions, but under the Wisconsin law, if Mr. Rittenhouse provoked Mr. Huber's actions with the skateboard, then he can't use self-defense. So that provocation argument is much stronger for Mr. Huber's death for the prosecution than it is, I think, for Mr. Rosenbaum's death, because it was really between the killing of Mr. Rosenbaum and then the killing of Mr. Huber and injuring others that I think the jury's going to have an easier time finding Mr. Rittenhouse's actions unreasonable.
Alan, let's talk about this jury. These are the first few hours of deliberation before lunch. What are these first few hours like, and what do you take away from the first request we received from this jury?
It's not surprising they asked for the law. There's so many terms in there, things that they're not familiar with. Just hearing it once, it's impossible. They're ambiguous terms and terms that need repeating. So it's pretty typical of jurors to request the law, go back over it to set the roadmap in the course of deliberation. One of the things that I'm pretty sure this is happening too is the jury now, as they get to unburden themselves. They get to talk about the case. That's one thing that jurors don't get to do. So think about it. In people's lives, there's nothing akin to having to sit through a week, 2 weeks, testimony, witnesses, all this, and you can't say a word about it. So what I've noticed in mock jury deliberations and in talking to jurors after a case is that right out of the gate, they just start talking about different aspects of the case. Did they like this witness? Did they not like Kyle Rittenhouse on the stand? This is how I feel. It's unburdening. It provides relief. And so once that happens, personalities start to emerge, alliances form, and then that'll set the course of what'll be a fascinating deliberation.
And then I have another question about the jury, Alan, for you. I mean, you heard Kim say that the instructions were confusing. They were incomprehensible. I mean, so who is the person who takes this bull by the horns and shepherds the jury through trying to figure out what all of that meant?
So much the judge can do, even though we show sometimes he's willing to insert himself into the process. One or two jurors are going to have to step up, and they're going to have to really focus in on certain parts of the instructions that they think are relevant to the deliberation, and they're going to have to build some consensus. They're going to try to derive some meaning from the different aspects of the instructions, and then go from there. It's an arduous task for the jury, and they have their work cut out for them.
Kim, back to you. I want you to listen to what Judge Schrader here said in charging this jury and the political element that were part of these instructions, and then we'll talk on the other side. Here's Judge Schrader.
You will pay no heed to the opinions of anyone, even the President of the United States or the President before him. The founders of our country gave you, and you alone, the power and the duty to decide this case based solely on the evidence presented in this court.
I mean, you're the prosecutor here, but I've never heard anything like that. What do you make of what you heard from the judge?
Well, I think that might be partially in response to the defense's argument that this is a political prosecution, that essentially Wisconsin, the state, was looking to have a scapegoat for what happened in Kenosha in August. I mean, there are political implications here. Many of them, of course, race is a big issue. Of course, many people, I think, rightly would believe that if Mr. Rittenhouse were a person of color, it would have been handled very differently, particularly the part of the video where he's literally walking by police officers after having killed 2 people and injured a third very seriously, blew off his shoulder essentially, people calling out that person killed someone and they let him walk away. The second thing I think has to do with Wisconsin's open carry law. This is really a bizarre clash of legal principles here. On the one hand, we have the Second Amendment, which I think many people believe is unlimited, not true actually as a matter of constitutional law. But also we have this self-defense that's built into Wisconsin criminal law. So the question is, sure, we have self-defense, but you also have open carry laws with an AR-15 and Mr. Rittenhouse at 17 who testified that he had no idea what the gun's capabilities were, or I'm paraphrasing, or what the ammunition capability was. So there are major political overtones, and as we know, the governor of Wisconsin has 500 National Guard troops at the ready with the expectation that either an acquittal or a conviction could cause some serious chaos or maybe even more violence in the streets.
Alan, about that, how much do you think that the individual jurors' feelings about gun rights will play into their decision here?
Role, and I'm sure it was thoroughly discussed in voir dire, and all the parties asking the questions will know about it, the prosecution and the defense. So they know really well about these 18 jurors. Now, voir dire was somewhat limited, so they didn't get to delve into nearly as many topics as I think they would have wanted to, but they have a pretty good sense of what their attitudes are about guns and things that are related to that.
All right, Alan Tuerkheimer, Kim Whaley, thank you both.